Okay, well, welcome back. This is, I think, about our third podcast now, talking about this new overtime law. I'm Becky Freemal with WFXR News, and we are doing our weekly segment, Virginia at Work, with Lynda McNutt Foster with Cortex Leadership Consulting. And with us is Chris Head, a business owner in our area, and Tommy Strelka, an attorney from Roanoke. Wow. So we just wrapped up a lot of information from being an owner standpoint. Let's talk a little bit, Tommy, we're going to put you on the spot, on the legality of this all. Since our story aired, we have gotten inundated with questions. It has been shared all over social media. We have heard from tow truck owners, a sod farmer, teachers, I'm writing the list down here, firefighter, you name it. Everyone seems a tad confused. My first question is, are there any exemptions? Because people keep saying, doesn't matter what you do or how much you make, everyone's going to be affected. But that's not exactly true.
No, there are exemptions. The thing is you just listed off a different list of jobs.
Yes.
And the thing is that this law is so complicated that there's kind of a separate subset of law and regulations and case law that regards each one of these positions. Most teachers, for instance, are exempt by the very fact that they are teachers under what's called the professional exemption. What's known as the white-collar exemptions are actually three separate exemptions. You have the professional, the executive, and the administrative. The administrative is probably the one that is going to be affected most widely by this change, but the salary level change for the executive and for the administrative both get updated to this 47.6 47,476. Yeah, 47,476.
Yeah.
So there you have it. So.
Speaking about exemptions, also talk about, and I mean, this doesn't really fall into exemptions, but I guess it could, the small businesses. Some people say, well, I'm a small business owner, it's not going to affect me. But you're saying you have to be a pretty darn small business owner for it not to affect you.
You'd have to be pretty small. The FLSA and federal overtime requirements apply to employers who have gross sales of at least $500,000. For most employers, it gets there pretty quickly. If you have 4 or 5 employees, 6 employees, it's going to probably be covered. Most employers are covered. It's only very small businesses, out-of-the-house businesses, that wouldn't be typically covered.
So let's go through some of these questions, and I have a list of them. We can talk with, I'm going to actually just read this particular one, just a part of it. I work as a fitness manager, and I am the only paid employee at the facility. All others are independent contractors. I am paid a weekly salary that I get paid on the 1st and 15th of each month, which is normal for most. This salary does not equal anywhere close to the figure that was put in for the information about this new overtime labor law. I was wondering, is there certain circumstances of the type of employee you are to be eligible for that increase in pay up to $47,000?
Okay, well, interesting way that this employee is putting it. There's no eligibility for an increase in pay. Mm-hmm. That's going to be the employer's decision to try to navigate this, rocky, rapid river that we're in. But so if this employee is making currently more than, say, $24,000, and they are there's a salary test and there's also a duties test. And this employee could fall under maybe the executive or the administrative exemption. To fall under the executive exemption, this employee would have to be directing the work of 2 subordinate employees. Those contract employees could qualify as that if they're directing that person. In that case, if this employee is paid less in December 1st than the $47,000 figure that the FLSA is going to be raised to, and they work more than 40 hours a week, this employee would be owed overtime. Now, they may fall under the administrative exemption. The administrative exemption also has a duties test. They have to perform non-manual labor, and they also have to execute independent discretion of matters of significance, and that is just a wonderfully abstract statement that allows lawyers to charge a lot amount per hour to argue it. And that's the whole thing, is that you take that statement, and lawyers and judges have applied that statement to all the different vocations that can be, and it gets so narrowly defined to each vocation, and so and the FLSA job titles don't matter. It's what you're actually doing. So everyone's job really needs to be looked at independently alongside of the various tests and regulations of the FLSA to determine if it's going to apply or not.
Chris, I'm gonna head your way here for a minute. You had mentioned earlier when we were speaking about the fact that you, your general manager, and your co-owner, also your wife, are all going to basically take a retreat. Not the best retreat in the world. You're not getting spas and massages.
I don't know. We might just because we'll need it to de-stress.
You may, yes, you might want to throw in a massage or two, just to discuss how this is all going to work. Talk about that duties test from an employer's perspective. Are you going to look down and put professional, executive, administrative, and see if you have?
Well, we already have that pretty much done.
Okay.
Because again, I mentioned that about half of our administrative staff, and that's the only that this really affects for us is the administrative piece, and not the caregivers that work for us because they're already hourly. They're broken down already as to who's salaried and who's hourly, and that's decided based on the duties test, and the duties tests really haven't changed with this. So we'll hope that it doesn't, and that we can continue to go down that same road. It really is going to be about compensation, and it's going to be about the question that you had from the person at the fitness center there was like, you're not going to get a bump in pay. You're going to go to hourly. I can just go ahead and tell you that's because there's not going to be, particularly if you say you're paid well below this now.
Right.
There's not going to be enough money to take it all the way up there. You just can't wave a wand and suddenly be thrown into this other threshold. Now you're going to be clocking in. You're going to be clocking out. I mean, just strap in and figure out that that's what's going to happen.
And I feel that you and I may have the same perception that the decision makers in charge maybe thought that perhaps there'd be more employers who would be inclined to raise these salaries to get to that exemption level. Perhaps more than they will, and we'll have to see how that plays out. But I think that was what the underlying policy was behind this.
Yeah, well, I'm certain based on their response. I mean, the press conference that President Obama and Tom Perez, the Secretary of Labor, had said this is gonna do these things, and it's not gonna do that. I mean, it just because you can't get there from here without fundamentally changing something.
Well, where does the money come from? Okay, so you already have companies running lean, right? From the recession, they're running very lean, and then everything's a very competitive marketplace. I don't have any clients that don't have a competitor. So you're trying to run really lean in a really competitive marketplace, and this law comes into effect. It's not like, somebody's just going to hand you an extra $50,000, $100,000. Some of them it'll cost $500,000 a year in overtime. And you're talking about large companies are going to. Where does that money come from? This is pure economics to me, and the business owners. And it's
gonna change too. I think we mentioned in the last segment a little bit of the culture here, just as a scenario that I'm concerned with right now. If somebody is working on something that may fall outside their job description, but it's beneficial to them and to the company, and that's fine. So you're doing that because you're salaried, and that's okay. All of a sudden, if you've been converted to hourly, and you walk by as a manager, and you're looking at that, and you're going, "What are you doing?"
Yeah.
Well, I'm working on this. That's not your job.
Right.
You got to be doing your job, because at the end of the day, at 5:00, get up and leave. You can't stay here because I can't afford to pay you the overtime. So get out.
Whoa.
And that means you're going to have a lot of that flexibility. Now, hopefully we won't do that. We'll find a way to get that done. But there's just a lot of issues with that we're going to have to sort through as to how that's going to get managed. Because I know last year in my industry, in-home caregiving had been exempt from minimum wage and overtime. And though the FLSA in the law still says that you are, the Department of Labor has opined and now ruled that it doesn't apply if you're working for an agency, only if you are hired individually by the person actually receiving the care. So all of the agencies in the country that were exempt last year had to suddenly start paying overtime to the caregivers. Now you can argue back and forth, and there's some pluses and minuses. We tried to present some scenarios that would be a sort of a middle ground. Just was flat out everything is compensable time, and that's okay. That's where we are, and we're all there, and it affected everybody in the industry the same. But most of us had pretty significant rate increases as a result of that, and so it costs more. People are buying less. You're moving things around, but the impact on the bottom line for that for things was what it's costing us in overtime, and then the extra administrative steps to manage that. Because I mean, my wife and I sit down and look at reports. We've done this for the last couple of days from these meetings, looking carefully, how do we help manage that so that it doesn't get out of control, and that you don't end up with some employees that get a bunch of overtime and other people that aren't getting enough hours. How are you managing all of this? It becomes much more complex when you have to start thinking about it. When you start bringing those complexities now into the administrative world, golly day, this is going to get a mess.
Tommy, question for you. On-call.
Yes. So there was someone who viewed and questioned in about whether overtime applied when you are on call. So this employee works 40 hours a week, doing the legitimate duties of their job at the work site, but then when they go home 7 days a week, they are considered to be on call. In most situations, that is not going to be compensable under the FLSA, and you are not owed overtime in most situations for when you are on call. If you're at your own house and you are only, for instance, called maybe say once or twice a week, and if you're, for instance, you leave a note with your employer, information with your employer as an employee of where you can be contacted and so forth, that is not going to be compensable. When it becomes compensable is when, to meet the duties of your job, you have to be very close to the business when you are not physically there. In other words, you have to stay on the premises or live very close to the premises, and you're also, while on call, getting very frequent contacts from your employer to do additional tasks. And under that very strenuous kind of test can you be compensated for overtime under the FLSA. But most on-call situations, the FLSA would have no effect.
So it sounds like, say you're not even an on-call employee, but we've talked about this. Executives get done at midnight and they're exhausted and they're like, oh, I finally have time now to send out some emails. If you send out an email and an employee responds at 1 o'clock in the morning because they happen to be awake, that's not going to be considered overtime.
Well, okay, for who? Are we talking about the employee or the executive, or who are we talking about?
The employee who responds to the email.
It depends.
Because they're far away from home and not on call.
It depends if they're exempt or not, because if they answer that email, they're working. They're working.
But wouldn't they be working if they're on call? I'm confused between the two.
On call, if they actually have to, so on-call means, under the FLSA, that you are available to then come to the work site or leave your premises and go to do work at an additional work site. Okay.
So if you get the call but don't go to the work site.
If you get the call but don't go, you're not working. Okay.
Okay.
Now, if you get a call and then all of a sudden you go to the work site and you're working during those hours, you have to be paid for those hours that you're actually working. The person who who emailed was questioning about basically those hours where you're in limbo, where you're not really free to, maybe go on a vacation or take a trip out to the lake for the weekend because you have to be available.
Right.
And so is that time, the time that you have to be available, is that compensable under the FLSA? No, it's not.
Because that's like city snowplow people.
Right.
Like when there's a big snowstorm coming, those employees have to be on call.
Correct.
But they don't get paid for being on call. They only get paid if they're called and the snow, thank God, in Roanoke.
Right.
How many times have we called for snow and it didn't happen? There was a question in here too that we had gotten about, is there going to be anything in place to prevent employers from reducing the hourly pay to allow for built-in overtime? No, there won't. There was another question that we came up with that came up about the fact that it's the overtime is a week-to-week thing. So a lot of times right now it's a comp issue. If I'm on hourly and I work 60 hours this week, then next week I only work 20 hours. You might be able to avoid any overtime pay, but with this, right? If I work 60 hours, 41 hours in a week, I get paid 1 hour of overtime.
Right. Anytime over 40 under that week snapshot. But this is how complicated it gets, because it gets different if you're a state agency. If you're a government, they have additional kind of they can use comp time. They can use things where if you have that 60 hours one week, they can then use what's called comp time, which is a bank of hours that they can use to balance it out for that employee the next week. A lot of people who work for the government
can do that, but the private industry can't
correct.
do it.
There's different that's how it gets very
So I told you,
complicated.
my voice gets all high.
Very complicated. Yeah,
It does.
I'm
does.
such an entrepreneur at heart. I am
This is
such a business
political.
owner. I can't
I just-
even. This
I
is
couldn't help
crazy.
myself. I'm
But
sorry.
yeah. And I'm not even political. I'm not political.
Okay, so I'm while her voice is going high pitched, I'm going to actually ask that question right here, and it's a very simple question I got from someone. How will this affect state employees? And that's a very broad question, but
Right.
so there's some differences.
Well, this change is going to affect employees regardless of whether they're private employees or state employees. So the FLSA applies to local government employees, it applies to state employees, it applies to federal employees. So the FLSA, if we're talking about this change in the salary level for the white-collar exemptions, it doesn't matter if they're state or private. It applies.
Okay.
What about? I thought the firefighter question was a great. I just spoke to all my friends with the firefighters. They had to sound the alarm. Hello, Tiffany Bradbury out there who just put on a fantastic event.
Giving a shout out.
Yeah, giving a shout out for the city and all the
Where was the
state firefighters.
that?
But there was a question from the firefighters, a firefighter about they're a career
okay.
firefighter for a local jurisdiction.
This is exactly what I was talking
currently
about.
work 240 hours a month while on salary. Like, what that you answered? That's what you were trying to answer. Okay.
This sounds like to me comp time, because comp time is typically given in a 240-hour slot, and so it allows a bank of hours under for governmental entities to, and it's there also for employees who can work kind of more infrequent hours. Certain sheriff's deputies, police officers, and of course firefighters and first responders, who might be working irregular hours. So if there's a tendency to work irregular hours, there's a policy in the FLSA to allow governmental entities to not have to be exposed to the same liability for overtime as the typical employer. So they allow them this comp time.
If I'm on straight commission as a salesperson, because a lot of people are hired, they're on straight commission, and I work 80 hours a week and I don't make nothing because I ain't selling nothing. Does this apply? Does this change anything about commissioned employees that are in sales?
As you phrased it, no. The FLSA doesn't care about your lost commissions or the fact that you may have agreed to a position in which you are full commission but you can't sell anything. That's just an unfortunate situation. It's very sad. But
highly unfortunate.
The commission is not a death knell to FLSA coverage. So here's how it works. So an employee can still be paid commission and owed overtime if the commission doesn't equal half or more of what their take home is in a representative period, and that representative period is determined by the employer. It has to be the minimum a month, can be as great as a year. And so the employer picks a period of time, and they look at the employee's wages, and if the sales commissions aren't as high as the base salary, then the FLSA, the overtime could apply, and that they may.
So tell me this in English. So if I have, I have a lot of friends that are in sales. I was in sales for a long time. So you have a salary of $200 a week, $300 a week, let's say, a base. You get a base salary of $20,000 a year, but then your commissions are $10,000 a year, $12,000 a year, and you're putting in 80 hours a week.
Under that paradigm, as you said, which is pretty simple, that employee will most likely be owed overtime for hours worked beyond 40 if their commissions aren't exceeding that base salary.
So most employers are probably just going to do the draw and not have a base salary if they can avoid it.
And they're still under that 47,000 salary test.
They're going to do draws and
exactly.
everything else instead of base salary.
You're going to see a lot of 1099 employees.
Exactly. No, absolutely.
That's what I'm saying.
Yeah.
Subcontractors, 1099s, that's going to pump this up in a way.
The FLSA has changed how I do business. I go after companies for screwing up the FLSA. And I have to admit, it's the easiest thing to do on planet Earth because it's just so complicated. But I'm terrified because I know what can happen. And this has factored into how I do my business. And so, yes, we do use 1099 employees. And the employees that we do have on staff 38 hours. 38 hours. I'm scared to death of even going to 40. So, it really affects how I practice, because it's such a trap. It's what I call certain cases bear trap cases, and screwing up the FLSA is a bear trap case. You can't talk your way out of it. You can't, even if it was just a simple, honest, good faith mistake in what is the most complicated legislation that an employer should probably have to deal with, doesn't matter. Violation is violation.
The Affordable Care Act is the most complicated piece of legislation.
Sorry, part of it.
But employers also have to do
Trust me.
As a Republican delegate, he could get into that one for a minute.
Yeah.
As a business owner that was affected by that one, I could get into that.
Side
But
of
we'll
it
stick
right
to
And here's a question we have, and maybe you answer to this. I'm not sure if this fits into that. If you work X amount of hours one week, like 60, and you can do 20 the next, and you're saying no, it's week to week. This person asks, I'm wondering if this law will affect fluctuating work week employees.
Well, I mean, it's looked at week per week, but if like I just mentioned, a type of employment regarding commission where you're not looking week to week, we might be looking at a month or 6 months. So the salary. It's really the typical though is looked at as a 40 hours. That they work more than 40 hours that week.
That's it. Done.
That's it.
That's a nice simple answer, at least. I mean, that does not fluctuate.
Unless they work for a state agency, in which comp time can become a part of it. I mean,
it seems so clean for just a second.
But it never is. It doesn't. It spins out of control so easily. That's the whole thing.
Exactly. I think do you have any other ones that you're looking at, Lynda?
No, I think I was looking to make sure, because we had. I really feel like we covered all the questions we've gotten so far.
Right. Yes.
So yeah, I think this is this is real in-depth conversation that's covering employers, employees. I really appreciate morale. I really appreciate. Number one, you guys just making your time at a drop of a hat. We were like, this is a story. People need this information, and especially when you're saying now employers are still working through it. Employees may not feel comfortable asking about it. We want to be the resource so that everybody can sort of have information that they can use.
Perfect. And this is not the last, I am sure, that you have all heard from us. There will be plenty more conversations to come. But again, I want to thank Lynda McNutt Foster with Cortex Leadership, Chris Head, and Tommy Strelka. And again, I'm Becky Freemal with WFXR News. We will have this, of course, on our website, virginiafirst.com. Do not fear. We'll have links to Lynda's articles and everything else, and we will continue to take questions as well. Thanks so much.
Thank you.